We are discussing resolutions. The defendant apparently is working on some sort of lawsuit settlement that should be able to take care of his arrearages, and then we can resolve this matter at that point.
Okay, all right. And that's your understanding as well?
I haven't discussed that with my client yet, Your Honor. We did have conversation, Ms. Brenner and I, the other day, and my client did represent that he was the victim in an automobile accident, and they are through mediation already, and it's close to the amount that he would receive. So they rejected the offers, I understand it, but it's still ongoing, trying to get a little bit more. So, yeah, with that, and what we discussed was, you know, if he paid it all up, it might be an outright dismissal. That's not a firm offer, but that if it was a big chunk, then maybe it'd go down to a misdemeanor. But it all depends on the outcome of this automobile case. So with that, has your case settled yet, Mr. Duncan?
Not yet.
All right, but that's accurate what I indicated to the court, is that correct?
Yes, sir.
Okay, so with that, I would recommend that you just waive today's hearing because they would just show how much you owed at the preliminary exam at the next phase, and then we would be bound over to circuit court. So this way, we'll just waive that, go up to circuit court, and then we'll try to resolve it there, depending on the outcome of your case. Are you okay with waiving your preliminary exam today, which you have a right to? Or today?
Yes, sir. Whatever you said. That's fine.
Yeah, and I understand that that you're appearing by Zoom and that given the time zone, you're off a little bit, and so appreciate you.
Yeah, thank you, sir.
And so let me just go through with what your attorney was saying and what it's the understanding of the attorneys. So, Mr. Duncan, you do have the right to a preliminary examination where it must be shown that a crime was committed and probable cause exists to charge you with the crime. By waiving means now you voluntarily waive your right to a preliminary exam and understand that you'll be bound over to circuit court on the charge in the complaint and warrant. And as your attorney explained to you, you won't have that hearing, and then the date, I don't know if we have a date set for the prelim. If there's any future court date in this court, it would be adjourned, so, or canceled. So you wish to waive as well, Mr. Duncan?
Yes, sir.
Court then determines the waiver to be knowingly, voluntarily, and understandingly provided. Given that Mr. Duncan was aware that maybe the court date was 2 hours from now, given he's in a different time zone. If there is, normally these are unconditional waivers, but given that this has kind of all occurred like now, I would probably accept a waiver, or I mean the remand, if a preliminary exam was necessary. It doesn't sound like it's going to be, but just to let everyone know, just place it on the record. Given that you also haven't had time to set with your client in a meaningful time other than an open court, so just to place it on the record. Mr. Duncan, may your attorney sign your name as well to what I read to you just a few moments ago as to the waiver?
Yes, sir.
All right, and then Ms. Brenner, may I sign your name as well to the waiver?
Yes, Your Honor. Thank you.
All right, I'm just going to do that right now. By ATF via Zoom with permission. Okay, and then I will present the bind over for defendant's signature. Is there anything further, Ms. Brenner?
No, Your Honor. Thank you.
Anything further on this matter, Mr. Vogel?
Nothing further, thank you.
All right, then. All right, thank you, Mr. Duncan. Be well, take care, and have a good day. Thank you, Ms. Brenner. Take
Thank you,
care.
John.
Okay. Bye-bye.
John, you gotta sign this name. Just do it by itself.
All right, and then I'm going to continue his bond as well on that case. All right. Now recalling in the matter of People versus Johnson on 24596 and 24597, appearances again for the record.
Good morning again, Your Honor. Counsel, for the record, Dan Van Orman for the people.
John Vogel on behalf of the defendant, Your Honor.
Okay, and we're ready to procead.
We are, Your Honor. Apologies for the delay. My officer is here.
Okay, and just to note that the order, all orders are still in effect, so I'll leave it up to the parties to make sure that that's enforced as far as the witnesses.
Everybody's question, the only, Chief Kelly's my officer in charge, so.
Yep, nope, if he's, with the exception of the investigating officer. You want to call your next witness?
This time the people will call Officer Ernest Falco.
Officer, if you could approach me, I'm gonna pause right by that black mic and then raise your right hand for me. You do solemnly swear to tell the truth, the whole truth, and the truth so help you God. Have a seat right there, left here.
Yeah, I don't know, Mr. Boville, if we were able to, I mean, I don't have a problem with you, because I know those monitors, but I don't know if we even lowered them, if that would help.
Yeah.
Does that work?
Yeah, now I can see him.
Okay, yeah, I'm so sorry about that, then I'd rather have you, so you're your clients in case you have to have any occasion. Your witness.
Thank you. Officer, good morning. Your full name for the record,
Ernest Thomas Folco,
current occupation,
police officer,
with which department,
Carlton Township Police Department,
for how long?
approximately 2 years now.
Okay. So my math is correct. You were working, you were in that capacity or in that employment late last year, October, November, correct?
Yes, sir.
Direct your attention to November 22nd, 23. Did you have occasion to speak with somebody by the name of Connie Barst?
Yes, sir.
And was that at 4034 Michigan in Saginaw?
Yes,
Or
sir.
Carlton? We can agree that's in Saginaw County as well.
Yes, sir.
And just without getting into specifics, what was the nature of your conversation? What caused you to speak?
I was dispatched to her home reference of possible forgery. So when I arrived, I spoke with her where she was able to provide her statements.
Okay. As a result of that, did you have an occasion, if ever, to speak with somebody by the name of Eric Johnson?
Yes, sir.
Is Eric Johnson present in court?
Yes, sir.
Would you indicate for the court where he's seated and what he's wearing?
On the defendant's side, looks like a work t-shirt.
Shall reflect ID.
Thank you. Do you recall roughly when that conversation took place?
I believe it was the day of that the report was made, shortly after.
So late November of last year?
Yes, sir.
Okay. And the reason for your contact with Mr. Johnson?
Because I understood that he was contracted to work for the complainant at the capacity of a contractor to replace certain utilities. I believe it was like flooring or a door more specifically. And she believed that.
Could you speak up a little, please?
I'm sorry. And she believed that the check may have been deposited by Mr. Johnson. So my first indication was to contact him and get his side of the story.
Okay. Was he under arrest at that time?
Yep,
Was he free to leave or terminate the conversation if he desired?
absolutely. He was not detained.
Okay. And what, if anything, what inquiry did you make and what, if anything, did you learn with respect to that, those topics?
If you don't mind, I'd like to refer to my report.
You can refresh your recollection when you're done doing so.
Okay, so actually, I was able to speak to him in person because the contact information I received for him was either old or out of service. So I went to his home where I spoke to him. I brought up Bart's name. He recollected that he was repairing some water damage for her at her house, which is the venue previously listed. When I brought up the check, sorry.
Go ahead.
So we discussed the check in question. And from my understanding is he received that check from the victim was what he was, advising me at that point.
Did he tell you anything, or what, if anything, did he say about how he received the check, in person?
I tried to get more specifics on that. We didn't get much progress. I wasn't sure if the check was mailed to him or if he handed it in person. He doesn't, I don't believe he recalled where he received the check from. He did elaborate that the check was signed by him. He couldn't remember if he signed with either his name or somebody else's name.
And did he advise what he did with the check?
It was deposited into a Chase Bank is what he told me.
Now, in the course of your investigation, did you have occasion to visit Chase Bank and or any other bank?
I did. I visited Chase Bank. I spoke with their security team that was directed by their manager. And with information I was able to provide by the check, they determined that the
I'll
check.
object to hearsay.
Okay.
What did you do after you spoke with the security team?
I provided information related to the check to their team who specializes in these cases.
Okay,
And they were able to determine that the.
I'm gonna object to hearsay.
Yeah,
specifically, did there come a time, if ever, when you obtained a check or a copy of the check?
Yes, sir.
Approach the witness, or approach the bench, Your Honor.
yes.
I believe that those are no longer in the court's possession. Either you have them or.
Do you have the
You both
exhibits,
have
Jim?
I give it back to you.
Okay, my apologies. My apologies. I'm approaching with what's been admitted as people's proposed one. Do you recognize this?
Yes, sir.
And what is it?
This is a screenshot photo of the copy of the check.
Okay, that's the check you obtained in the course of the investigation?
Yes, sir.
Okay. And who is that check made out to?
Connie and it says Randy Barst.
Okay, and is there some writing on the back of that check?
There is. Pay to the order of.
I think it speaks for itself.
Okay.
Now, after observing the copy of that, or that exhibit, what, if anything, did you do after that?
I began by collecting her signatures. Barst was able to provide multiple signatures from previous insurance documentation.
With respect to traffic at the bank or activity at the bank, what investigation did you continue to conduct after reviewing it?
Ultimately, that led me to a PNC Bank.
Okay. And what did you do when you arrived there?
I also provided information related to the check in front of me.
And what did you do as a result of the information that you provided and, if any, obtained?
Reviewed security cameras around the date and time of the check's deposit.
And did you have occasion to see anybody that caused you to make further inquiry?
Yes, after speaking with the teller,
I'll object to hearsay.
I'm not offering what he said to the teller as proof of anything, you know, only the truth of the matter. I'm asking for what he did as a result of what you.
It sounded like he was going to say something that a teller
What
said,
the
so.
teller said.
so I'm-
Yeah, don't tell us what the teller said to you.
Right. So after I spoke with the teller, I'll phrase it that way, and I was able to obtain the security camera footage, I saw an individual who made the deposit the exact time and date with this check.
And is that person that you observed on the video present in the court?
I believe so.
Okay, would you indicate for the court where he or she is seated, what he or she is wearing?
Near the defendant, black t-shirt, maybe gray.
Your Honor, may the record reflect identification of the co-defendant, Kerry Jones.
Shall reflect ID.
Thank you. Now, as I understand it, were you familiar with people that, and I don't need to know how, were you familiar with people that knew defendant Kerry Johnson?
Yes, sir.
Okay. And what, if anything, did you do with respect to that following what you observed on the video?
Being not having any previous contact information, or personal contact, the identity of this person who is in the video is determined through a lien search through Secretary of State. So photo ID.
And what did you do, if anything, after that to further the investigation?
I believe I attempted follow-up.
Did there come a time, if I may, did there come a time, if ever, where you recontacted the defendant, Mr. Johnson, Eric Johnson?
I believe so, yes. It would have been over a phone call.
Okay. And were you familiar, did you have occasion to speak to someone when you were on the telephone?
Yes, sir.
And were you familiar with defendant Eric Johnson's voice at the time?
Yes,
Was it Mr. Johnson you were speaking to?
I believe so.
Okay. And what, if anything, came out of that conversation?
The conversation I had with him was shortly after leaving his home. Because again, the contact information I had at the time was bad. So he actually contacted me knowing that I was at his house. He said he's seen me on security cameras, and he wanted to talk. So we had a conversation regarding where I was at in the investigation at the time.
And did there come a time, if ever, when you inquired about the check?
Yes,
Okay.
yep,
And that was the check he had admitted knowing of, if not having possession of sometime previous, correct?
yes, sir.
What, if anything, did he say about that?
He said at first he said he was gonna pay it back, he was gonna make things right with Barst. At this point in the conversation, he said he had no plans on to follow through with that.
Did there come a time, if ever, when you made contact with somebody by the name of Jane Marie Westphal?
Yes, sir.
And what was the reason for that contact?
I understood that Jamie had prior contacts with Johnson, references a similar incident. He was previously contracted through him as well,
Do you know if that was with Mr. Johnson or Ms. Johnson or both?
Mr. Johnson.
No further questions.
Mr. Bogo.
Thank you, Your Honor. The funds that are represented in the check did did Connie Barst ever indicate to you that she had told the defendant to get the check?
No, sir.
Do you have any idea how? Well, strike that. Was the money refunded to Mrs. Barst?
I don't believe so.
You don't know?
I don't.
Okay. Where's the exhibit? Okay, you still have exhibit number 1.
Yes, sir.
You never saw anybody sign that check, did you?
I did not.
Did you ever see at that time that the floor had, when you were over at her house, did you ever inspect and see that the floor had been torn out of the basement?
I don't recall.
Okay, did you ever look to see if any work had been done?
No, I don't believe so.
Do you know, did you get into a conversation with Ms. Barst about what was supposed to be done for the money?
Yes, sir.
All right, but as I understand it, you never took a look to see what portion, if any, was earned?
No.
Okay. Nothing further.
Any redirect?
Won't be trying. No redirect, Your Honor.
All right, thank you, officer. You're all set. No further witnesses?
No further witnesses, Your Honor.
Any proofs?
Your Honor, we're not calling any witnesses. I just move that that Carrie Lynn Johnson the charges against her be dismissed. I don't believe there's been any evidence submitted that she had any knowledge or
Why don't
intent.
we do this? Let me have the people make their motion to bind over. I understand we will. Go ahead.
Respectfully disagree with that, but I'll talk about it. Your Honor, we moved to bind over as charged. I believe that people have shown for probable cause purposes with respect to defendant Eric Johnson, one, that the elements of false pretenses were that he took money, he did nothing. Two, with respect to uttering and publishing, the testimony is clear that a check was received. He acknowledged to his victim that he had the check. That check was later cashed or deposited at a bank by Ms. Johnson, which I'll get to in a minute. So respectfully, I think signing a check, signing somebody else's name to a check without their permission, testimony is uncontroverted with respect to that. I think the elements of both charges are met with respect to that defendant. With respect to Carrie Johnson, contrary to what's been suggested by Mr. Vogel, the testimony of Officer Falco indicates that the check, which was admitted as an exhibit, was deposited and was deposited at PNC Bank, and Ms. Johnson was observed in the bank at that time. Now, I suppose she could have one of several other accounts, but for probable cause purposes, Your Honor, I think we've met our burden as to UMP as to that defendant. I think the charges all should be bound over. Let the juries deal with the arguments that he's about to present.
Thank you, Your Honor. Again, as to Carrie Johnson, there's been no evidence that she had any intent, had any knowledge regarding the contract between, if there, whatever that was, it was not specific. Apparently there was some flooring to be torn out. I'm not sure what was to be put in and so forth, but between Eric Johnson, based on the evidence that was admitted, that there was, by the homeowner at least, evidence that they had some agreement and he was getting paid, the money was returned. However, there was a deposit made, as I understand it, by his wife, but she was never part of the agreement. There's no evidence that she knew that the check, whether it was by permission endorsed or otherwise, she simply deposited a business item, into an account. But so I don't see where there's any evidence to support her having any intent, Your Honor, to do something that was unlawful.
Where is the, if you want to expound further on the issue with regard to Ms. Carrie Johnson's knowledge?
I'll leave it to the court.
Okay, first with regard to, let me address the issues of Mr. Harry Johnson. Well, after listening to the testimony, particularly from the homeowner, the elements with regard to Eric Johnson and that check was received, it is not for the court to determine the facts in this case or what whether it should have been a civil matter or criminal matter. The people have brought the charge against the defendants, and now the issue is whether or not the people with the testimony presented to this court can maintain that. as far as the probable cause showing for this case to go forward. Many of the issues that were presented by the testimony, well, I think the court got a flavor of it, again, does not set as a trier of fact, but we'll note that with regard to Eric Johnson, the people did meet the burden as to the probable cause standard. With regard to Carrie Johnson, the elements with regard to uttering and publishing, that there is a knowledge component to the elements. Even though that the forger may not be identified, there is case law that does say that it does not matter whether the defendant knew who made the altercation. But going back to the main elements of the uttering and publishing, it is an element that the defendant did this knowingly, that the document was false, altered, forged, or counterfeit. That element has not been met by the people. So with regard to the failure of the people to meet all the elements with regard to the one count of uttering and publishing against Carrie Johnson, the court finds sufficient factual basis to support the bind over. However, as I mentioned earlier, there is sufficient evidence to establish probable cause on the bind over of counts 1 and 2. Is there anything further from the people?
I'm sorry, Your Honor, with respect to Carrie, the court is not binding over?
I am not binding over the element with regard to whether or not her knowledge that the document was false, altered, forged, or counterfeit has not been established. I mentioned the other part just because of whether the forger needed to be identified, but there was no knowledge that she knew.
And as to defendant Eric, he's bound over on both counts?
Yes.
Thank you.
Anything further?
Oh, yes, Your Honor. It was brought to my attention, and the victim is still in the hallway if need be, as well as the other witness we would have called, who has some of the documentation. Despite a no contact order, it's my understanding that the defendant Eric Johnson attempted to contact the victim. I believe the specific time and date to her, but my understanding was last night by text message. That's a violation of the provisions of the bond, which I understand include a no contact provision. And I'd ask the court sanction him for it.
No, I haven't looked there before. I don't believe another case there, a no contact. I'm not showing that a no contact was ever put in place, which wouldn't have been out of the ordinary because it was the court must have at the time believed that it was a
Chief went to obtain these bars, so I can report to my question.
yeah, so I guess the people were asking that there be no contact.
Well, absolutely, Your Honor. Any kind, direct, indirect text message or anything.
All right. Well, I find that the
We have no objection to adding that as a condition.
yeah, let the court also say there was no, the court doesn't view it as a violation because I don't believe that there was a no contact place. But we'll continue bond will be continued with a no contact with the victim.
And Your Honor, and I understand and accept the court's ruling as to the co-defendant, but what I definitely don't want to see is the defendant using the former co-defendant to.
Well, the no contact is, as in all the no contacts, that may not contact in person through a third party. So a no contact is a no contact.
Very well, thank you.
So, all right, anything else?
Did the court, for purposes of the record, want the exhibit?
I don't.
Okay.
Parties will hold on to those, and then,
All right.
so would people be filing a nullity process to appealing the court, or we'll do it.
All right, thank you, Your Honor.